Welcome back. If you just joined us, you are watching Good Morning Namibia. Now, the Office of the Labour Commissioner has issued a directive strictly enforcing rules against postponements in conciliation and arbitration hearings. The new measures aim to reduce unnecessary delays, ensure the timely resolution of labour disputes, and restore public confidence in the system. We will now engage Advocate John Diaz, who will give us an insight on the impact of the delayed labour cases, double bookings, and the training of union officials. Good morning, Mr. Diaz, and thank you so much for being here.
Great. Good morning. Am I audible enough? Can you hear me?
Yes.
All right, great. I'll say just a labour law advisor, not an advocate. Advocate is quite a prestigious accolade to give to senior practicing attorneys. Yeah.
Okay, thank you very much for that clarification.
Thanks.
So let's talk about the impact of these delays of resolving labour cases on employees. How much of an impact is it really to the affected employees?
Well, you will have to say former employees, because the reason why they go to the Labour Commissioner's office is to report that they've been unfairly dismissed, for example. So obviously the impact is quite catastrophic, especially when this person is a breadwinner. I mean, you don't need me for this. I mean, it's just so obvious that you can just pick up how a household can be affected and how, you know, the whole financial predicament of a family can really be impacted by such a dismissal. Now, and then you go to the Labour Commissioner's office because you have a legitimate and a genuine complaint to resolve. And then all these things are being delayed by all kinds of technicalities, for example. These are things that are frowned upon. Even the Supreme Court was very adamant to say, look, when you deal with labor disputes, okay, in the Van Jaarsberg case, to say, look, you should not rely too much on technicalities. You should focus on drilling down into the merits of the case, determine the real issues between the parties that are at dispute, and then finalize the matter. But you cannot utilize technical objections to sort of delay and delay, because that's not the spirit and the tenure within which the Labour Act was promulgated. It was promulgated to make sure that labour disputes are expeditiously dealt with and disposed of.
When we look at unions in organizations,
That's right.
What roles can they play to help curb this issue?
Well, look, the first thing, I'm not really trying to give advice to the unions. I'm just going to say my observation over the years, at least 13 years now that I've been around in the labour industry, after my prosecution stunt, is this. Unions must also invest in having lawyers, or at least law graduates, assist them. Institutional capacitation is very key. I mean, when you look at the other side of the coin, which is now the employers' federations, these people are represented by people that are legally trained. And then you have a comrade who's just as grade 10 or grade 12 and who wants to come sit there and represent their member with respect. I say this with respect, of course. Do you see the mismatch there, obviously? And then, you know, all I can say is put your members' money to good use. There's a lot of graduates that graduate on a daily basis being ushered out of universities, right? Assimilate those people into your structure. And then you have competent people that can be your office bearers that you can always issue out to go and represent your members throughout the country. That's key. But I'll leave it at that. Thank you.
When we look at this issue of the lawyers that you brought up, because I was going to touch on it a bit later, but I think it's fine that we talk about it now.
No problem.
How does having or not having a lawyer affect one's case? You know, just really explain that to us. And could lawyers also be a cause of delay in these cases?
Yes, there's two sides to the coin, right? The first side is obviously lawyers can be a great assistance in narrowing down the issues, curtailing them to the extent that it can only be a one or two issue that is dispositive towards dispute, right? So once that particular issue is determined, then the entire dispute is done. Or on the other side of the coin now is we can really be a pain by causing delays, raising technical objections that we know are so onerous, which the Supreme Court said you should not do that. You get what I'm saying? So as to delay matters, so as to gain our clients what you call trust, confidence. So those kinds of things happen. And I'm not shy to mention this. It does happen and it does delay matters. Certain arbitrators also from the onset tell you, no, I don't want lawyers. I can determine the dispute. The summary of dispute is so narrow, I know exactly what the issues are. So I can make a determination between the parties only, you see, because they are also adverse to the whole delay scenario.
So what kind of accountability procedures then can those aggrieved demand?
Well, it's twofold. It depends now where the delay comes from. Is it attributed to the arbitrator being delaying in terms of like handing down the rulings? Or is it because of the lawyers raising technical objections to delay the processes? Okay, perhaps they do have a genuine technical objection they would like to raise. In that case, they do. In that case, they're permitted to do so. So it depends where the blame comes from. And then you know exactly who to hold accountable. For arbitrators, for example, the labor commissioner is obviously their supervisor, right? And as their supervisor, if she, currently it's a she, if she detects that this particular arbitrator is failing in his task and his duties that he's appointed or he or she is appointed to do, right? Then it's incumbent on her as a supervisor to probe that particular misconduct, go to the ED and allow the ED to commission a panel to host a disciplinary hearing for this particular arbitrator. Because you will see, arbitrators are also public servants. Now, in terms of the Public Service Act and the regulations, Regulation 23 clearly charges the Labor Commission as a supervisor to bring about this action. If she fails to do that, then she herself is opening herself up for misconduct equally so. So these are the mechanisms that are already in place. It's already promulgated in 1995, all right, within the Public Service Act. So you have Section 25, within which there's at least 20 plus misconduct, acts of misconduct. So negligence on the part of the arbitrator, for example, indiligence, like you are not diligent in doing your job or executing a task, you can be held liable. On the other side, when lawyers are delaying things, then the arbitrator has the resort of Section 86, subsection 16, whereby if that particular conduct of an attorney is frivolous and vexatious, it is just to irritate the entire process and, you know, be an ache or pain to the other party, they can be visited with cost orders. So even the attorneys themselves can be issued with cost. So this we have seen from what Justice Masuku held in the case of Biekes versus Kruana. Yeah. So that is a revenue or avenue for the arbitrators to hold the lawyers account.
Okay.
Yes, ma'am.
There's also been an issue raised about double booking of cases. Looking at this issue locally and perhaps also referencing international methods, what remedies can be applied to solve this?
Okay. Look, a double booking is just purely let me just put it in a small, truncated view to say it's wrong of an attorney to do so.
Yeah.
You can't double book yourself. You can't commit yourself at two places at one time. You understand? Especially when it's a hearing. But if it's a mere postponement, if it's a case that is just set down for an adjournment, you can just perhaps just allow somebody else to assist you to go get the case postponed. But if you are committed in the High Court, and yet you're also committed in the Labor Commissioner for a full hearing, you can't do that. It's unethical of you to do that. Even the Law Society has spoken. Even the judges in the High Court have spoken.
So ethics should be applied here?
Yes. It's not reason enough for a case to be postponed. Just because you, according to your mismanagement of things, you double booked yourself. So that in itself has been a ground for asking for postponements quite a number of times. You know, the attorney is not available or the other party's attorney is not here because he's in Ochowarango or whatever the case might be. So that is purely not acceptable behavior. So we can also be held accountable to our rules as well.
Another issue that I want to, for us to discuss is maybe the issue of not meeting deadlines, even from the applicant side, to appeal. So what other procedures can be followed then when an applicant, for example, misses a deadline?
So when you appeal, appeals are quite set out in this Labor Act, right? Section 89 regulates appeal, subsection 1 in paragraph A. So it says 30 days once the arbitration award has been issued, you need to appeal if you are aggrieved by whatever the outcome is. Now, if you fail to do that, then the very first thing you need to do is once you file your notice of appeal, together with your grounds of appeal, setting out exactly why you believe this case was wrongly decided, you also need to couple that with a condonation application, asking the court to condone your late filing, right, in terms of Rule 17. You need to file that timeously, sub-Rule 4. You need to file it timelessly. First, the court will hear the condemnation application. You need to set out your reasons why you're late, the full extent of why you're late, and obviously, what are the prospects of success in your case. You need to stipulate it to the judge. And then the judge will adjudicate on that application first before granting the appeal to run its natural course.
As we round up our conversation, would you say that this directive by the Office of the Labour Commissioner will, of course, ease the burden and the process that many have been aggrieved by?
Well, look, the directive that was passed now on the 5th of September, I believe, by the Labour Commissioner, I think it's circular number 2, 09 and 2025. Well, there's two things I observe that are not there. The very first one is, firstly, obviously, postponements are regulated within the rules relating to the conduct of conciliation and arbitration, right? That's now Rule 29. Applicants can make applications to postpone a case. You need to furnish good reasons as to why you want to postpone a case, especially when it's set down for arbitration, because the goal is to hear the case as soon as possible and dispense of it. Yeah. So if you want to now come and apply for postponement, it's key that you need to set out proper grounds as to why. And sometimes the parties can agree in writing to say, okay, fine, let us postpone the case to X, Y date because of whatever reason. You forward it to the arbitrator can dispense of the application even in your absence. But it has to be done at least 7 days before the hearing itself. So that's key. It also helps with the management of the cases and allocation of dates so that the programs of the arbitrators are open enough to accommodate as many cases as possible. So you can't be a pain for the wheels of justice, you know, to move forward. You need to be an assistant.
Thank you so much for being here this morning.
Appreciate your time.
All right.